Hello, everyone. This is John Borkowski, and I'm a partner in the education group of the national law firm of Husch Blackwell, and I'm a longtime advocate of public education. On behalf of our education group, the firm, and our partners at the Council of the Great City Schools, it's my pleasure to welcome you back to the Emerging Legal Issues in Urban Education webinar series. We're excited to be continuing to offer this series to our clients around the country and to members of the Council. I'd like to begin by thanking our friends at the Council for their help with this series, particularly General Counsel Mary Lawson, who's joining us today and whose brainchild this particular webinar topic was. In addition, I'd like to thank you all for attending and participating in today's webinar about state versus local school board authority over public education. I also remind you that, as always, the discussion during this webinar is intended for general informational purposes only and should not be construed as legal advice. If you need legal advice, please consult privately with us or your regular legal counsel, as the answers to such questions always depend on your district's unique circumstances. Before we begin, I'd like to start with a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We'll try to answer all questions during our session today, but if a fuller answer is needed or if we run out of time, we'll try to answer the remaining questions via email. A PDF of this presentation is available in the program materials folder. This program also has been approved for continuing legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be mailed to you tomorrow, along with a recording of the webcast for sharing within your organization. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs. We want to make these programs of as much interest to you and as useful as possible. That's it for housekeeping items today. Let's go ahead and get started with our program. Joining me today are Mary Lawson and Eric Locker. Mary, as I mentioned, is the General Counsel of the Council of the Great City Schools. For 19 years before that, she served as an Assistant General Counsel in both Broward County Public Schools and Miami-Dade County Public Schools, over 16 years in Miami. And Mary actually began her career in the classroom, spending 8 years as a social studies teacher in the Pittsburgh Public Schools, Broward County Public Schools, and Anne Arundel, Maryland County Schools. Eric Locker, my colleague, is a labor and employment attorney in our Milwaukee office. Eric, like Mary, is also a former teacher. In his prior career as a music educator, he honed his ability to build relationships, break complex topics down into comprehensible parts, and succeed under pressure. While Eric's legal practice focuses on labor and employment issues, he also has a special interest in legal issues affecting public education, stemming both from his prior career as an educator and his mother's tenure on his hometown school board. So let's get started. Here's our agenda for today. I'm going to kick things off by talking a little bit about the tradition of local control over public education in the United States. Then I'm going to turn it over to Eric, who's going to talk about the more recent trend of increasing state-level control over public education. Mary will then talk about various mechanisms of state control. And we'll close out the session by talking to you, representatives of public school districts, about ways to push back against states' assertion of more control and to protect local control in your district and for your school board. So let's get started. You know, when we talk about local control, it really is a foundational idea in American education. And it started way back in the colonial period with legislation mandating that local communities start public school. It's also been something that's repeatedly discussed and mentioned in Supreme Court decisions, both where it's part of the court's substantive ruling on issues like substantive due process, but in wide-ranging other cases, in dicta, where the court mentions the history of local control when discussing issues as diverse as school funding and school desegregation. Let's talk a little bit more about those examples. When you talk about colonial era legislation, you can look all the way back to 1647 and the Old Deluder Satan Act, which in the Massachusetts Bay County required that towns of more than 50 families appoint a teacher and towns of more than 100 families establish a school. There were also land ordinances in the 1700s that mandated that land be set aside for establishment of public schools in local communities. So for early on in our history, there was this notion that the education of children was a local responsibility and a communal responsibility. The Supreme Court has also sort of recognized in substantive due process decisions the rights of parents and, by extension, in some cases, local communities to have control over public education. If you go back to the 1923 decision of Meyer versus Nebraska, you may recall that Nebraska tried to prevent instruction in foreign languages by state statute. And the court ruled in Meyer that this state statute violated the due process clause. The court held that while there's a legitimate state interest in encouraging a population that can engage in debate of and discussion of civic matters in England, that interest was not sufficient to justify a ban on instruction in a foreign language. Similarly, in Pierce versus Society of Sisters in 1925, when Oregon decided that it was going to mandate that all children attend public schools, the court pushed back and said, no, parents have a right to seek an alternative private school or homeschool education for their children. And so that while the state has an important interest in education, there's still a fundamental liberty interest that parents have to have control over how their children are educated. And these cases establish the idea that there's this individual liberty interest, particularly with respect to education, that can sometimes outweigh very legitimate state interests. Let's talk a little bit about these other cases I mentioned at the outset that really don't deal directly with the due process right to control a child's education that parents have, but deal with a variety of other issues. And in San Antonio versus Rodriguez, which is really a case about school funding and whether there was a fundamental constitutional right to education, the court also said in dicta things like the following: it cannot be seriously doubted that in Texas, education remains largely a local function, and that the preponderating bulk of all decisions affecting the schools is made and executed at the local level. Local control is valuable, the court said, because it facilitates participation by parents and local community members who really have the greatest stake in their education. And this whole philosophy is repeated in many Supreme Court cases in a lot of different areas. Another example is in Milliken versus Bradley, a desegregation case out of the state of Michigan. And this is a very often quoted statement that no single tradition in public education is more deeply rooted than local control over the operation of schools. Local autonomy has long been thought essential both to the maintenance of community concern and support for schools and to the quality of the educational process. And in that case, the court rejected a effort in the name of desegregation as part of a desegregation remedy to create a metropolitan-wide school district. And the court rejected that and said local communities in smaller units, even then, in smaller units, have a right to direct individually in individual smaller districts the education of their children, even when it limits the potential effective of a desegregation remedy. And so the tradition of local control is very, very strong and goes back a long time. Now, this decision in Milliken from the 1980s, 1970s, is still fairly recent. And there are subsequent cases from the Supreme Court that talk about the same thing. But we talked about this 7 years ago in another similar webinar. Even in 2017, there was a recognition that both the federal government and state governments had really, really started to impinge to a great degree on local control of education. Some of this started with the No Child Left Behind Act and an effort to impose federal standards on states and on local school districts, efforts by states taken pursuant to that law to try to force school districts to take particular actions. And there was an executive order in the Trump administration in 2017 that we talked about at the time, where there was really going to be an effort on returning power to local schools. And it was considered at the time sort of a political shot at the Obama administration's Race to the Top program, which was sort of an extension of No Child Left Behind. And it got a lot of attention, and we were sort of cautiously hopeful about the potential direction of that move. Unfortunately, since that time, as we'll talk about today, there really hasn't been a lot of progress in supporting local control over public education. Rather, while the federal government has not been as active in some areas as in prior years, state governments have increasingly exerted a great deal of control over local education. And you've got both the federal government putting demands on local school boards and state governments putting increasing demands on local school boards. And oftentimes, as we'll talk about today, the demands of the federal government and the state governments are in conflict. And so while we have this great tradition of local control, we're going to talk today about the many, many ways that control is being narrowed. And we're going to end up by encouraging you to think about ways that as representatives of local school boards, you may be able to push back against that. And with that, I'll turn it over to Eric to talk about this trend towards increasing state control over public education. Eric?
Thank you, John. Yeah, so as John mentioned, this is a spot where we see states really pushing in and pushing back on this idea of local control that's so deeply rooted in American tradition. And what we wanted to focus on today is not exactly what those disputes are, although there's going to be a number of examples of that, but this overarching of how they accomplish this goal of inserting state interests into these local school districts. And there's a number of tools in the state government toolboxes that the states use to try and effectuate their goals. The common ones we think of, and we're going to go through them today. State legislation, number one, first and foremost, what we see in the headlines day after day. But also how state attorney generals put some pressure on school boards through threatening legal action. We also have a role that the State Department of Education plays that a lot of us might not think about, but they do take a lot of action that just doesn't have as catchy of headlines as those bills and legislations do. And then last, we'll talk about governors. How does the executive, the chief political officer of a state, kind of go in and influence and make their whim the whim of local school districts? First off, as I alluded, is what we all think of, legislation. How does the state, I should say, impinge upon this idea of local control? And what you'll see is that there's a massive trend of what I've lovingly called copy, paste, legislate. Really had a pain to think of that great term. And it's this idea that we see one state, frequently it's Florida or some of these, more headline states that we see, Florida and Texas. They'll pass a law, they see that it works, or other states see that it passed, and then another state goes, why don't we try that? We'll just copy, paste it into our bills, and we'll see where it goes. And so we're going to walk through a number of examples of these legislations. So we'll have the individual state as an example, but know that there are countless other states that either have enacted the same legislation or very similar, or have bills that are going through the current houses of those states and trying to become law. First off, we have Florida. So this was one that I didn't hear about. It didn't make the headlines as much. And it was Florida implemented school board term limits. Prior to 2022 in this legislation, most school districts did not impose term limits. It just wasn't something that districts had considered. Either it had never become an issue or it was just not top of mind for those districts and the ideas of how they wanted to run their school boards. Then in 2022, the Florida State Legislature established a 12-year term limit for school board members. Maybe that's a great idea. Maybe that's a terrible idea. But the state government decided that that was what all local boards would have to conform to. Then in 2023, the state legislature decided, I don't think that's quite short enough for these term limits. And so they again limited it to 8 years. Their reasoning for that wasn't really given. It was more, they just stated that we thought this policy would better effectuate this board turnover in these local school districts. So related to that, we wanted to see how many of you have school board term limits. Like I mentioned, it's not common, was not common in Florida. Now it's universal in Florida. So if you want to click directly on the webinar presentation, you can click your answer for yes, whether it was imposed by the board, imposed by the state, or no, whether it was not imposed at all. Give you a couple seconds there. And personally for me, as John mentioned, my mother was on my local school board. I'd never heard of this prior. John, I don't know if you or Mary, if you'd heard of school board term limits in your experience with your clients.
I did toward the end of
I had not until this legislation passed.
Gotcha. So there you go. It sounds like both. It's a recent trend that we're seeing. So let's see how this shakes out. Looks like we said, most people don't have term limits. We did have one person where it was imposed by the state. I wonder whether this attendees in, it looks like one person, I should say, whether this attendees in Florida, but I have a feeling that might be the case. So not only does Florida have these school board term limits, the state legislature, just like many other state legislatures, we hear about these book bans. It starts to become like, oh, I thought that was last week's news. Well, it's coming a weekly or almost daily occurrence of these new book bans. Florida's is notable because what they have is they mandated a training for the individuals in schools who are reviewing the school library materials, which is a new idea. Instead of individual teachers, the state is going to have someone in the school to review all the school library materials and make sure that they're pornography free, suited to the students' needs, and age appropriate. And that age appropriate is where there's a lot of kind of discretion. What is age appropriate? What might be age appropriate to one school district may not be age appropriate to another, but the schools putting that in place, or the states putting that in place and making sure that all these library materials have to be reviewed. And there's actually criminal penalties for non-compliance. And of course, what happened is there's often schools had to pay for this training to get these teachers trained. And there's one individual in a school to cover this, to review all these classroom materials. And you think school library materials, that's not just when I go to check out a book when I'm in second grade, that's in my classroom. And there was one teacher that reported she had her books removed from her classroom because they were not reviewed in time for the next school year. And also, this legislation was not just this, review ban, but it made it way easier for people to challenge books and ban them. It allowed for anyone in the district to actually go in and ban, regardless if they had a student in the district or anything like that. So subsequent to that, Florida actually had to pass an amended legislation to limit the number of book bans because they saw them absolutely skyrocket. And so what they did was they limited who could actually challenge a book to those stakeholders that had an interest in that community. Utah also had a book ban, which I thought was very interesting and different, and shows you how this local idea of control can be just usurped by the state based on other local school districts' decisions. So under Utah's ban, if 3 districts decided that a book should be removed, that meant across the state, every single district had to remove that book, and it was viewed at the discretion of the State Board of Education, but they didn't have to address it. They could keep it as it is. They didn't have to actually look at it in the first place. And the reasoning behind it was that one state legislature said, it's so we don't have things that are criminally indecent and taken on one area, but then perhaps used in the classroom in another area, which just goes to show this exact point we're making, that states have had more and more interest in this local happenings, this local idea of control that's contrary to a lot of what we've seen from the Supreme Court and, as John said, all the way back to colonial legislation. Next up, we have armed security with Texas. So this was an interesting note and shows you how state legislatures might not consider the needs and the abilities of local school districts to comply with their regulations. So Texas passed a law that required every school campus to have an armed security officer. So I know a number of our districts here have, your high school might have 2 campuses. You have multiple elementary schools. So it's not one armed security officer for the district. It's one armed security officer for every separate campus that you have there. In one jurisdiction, in San Antonio's Northside ISD, they had 120 school campuses and only 100 officers in the entire local police department. So that's a shortage of 20 officers that they would need to hire for the entire, just to comply with this armed security requirement, not even following their local policing, community policing that they normally do. There was an option for states, for local school districts to petition for good cause to show that they couldn't comply, but it was more hoops to jump through for them to prove that they couldn't comply with the state's mandate. Further, it's not just that the states are impinging on the local school district and the school boards and making them feel like they're powerless. It's also frequently an annoyance to the parents. So in Indiana, we've seen a number of these kind of parental name notification laws that, if my child chooses to go by a different name in school, that I then have to tell them that I, as a teacher, would have to report that to the parent. So in Indiana, it started out limited just to transgender students. If a transgender student told a teacher they want to go by a different name, the teacher would have to tell the parent. By the time the legislation was passed, it was any time that a student requested a different name, regardless of the reason, regardless of transgender status, regardless of anything. And you can see on the screen some of those, frankly, ridiculous name notifications that went through because Rosemary wanted to go by Rosie, and that they had to tell her parent, and her parent was like, why are you telling me this? Rosie's always gone by Rosie. Or that Benjamin wanted to be called Ben. Then we have Mississippi, our transgender bathroom ban. And this is something that kind of one of those copy-paste legislate. This is done all over the place. We see a number of states have it. North Carolina and Utah have passed this legislation entirely. There's a number of states where it's working its way through their state legislature. It's through one house in some of them. And it said state schools must have single-sex restrooms, and sex is defined as what was assigned at birth. And you'll notice, as John alluded, this seems to be in contradiction to these new Biden Title IX regulations that are coming out, and how are schools going to follow both? And, it makes sense that Mississippi is one of those states that is indeed challenging those new Biden Title IX rules, but it's forcing these schools to make a difficult decision. State law, federal law, what do I do? So on this, we wanted to ask you guys, does your district have a bathroom ban? And whether it was imposed by the state, whether it was imposed by the board, and just trying to hear your thoughts. And I'll give you a couple of seconds to get in here while I take a drink. Give you about 5 more seconds and we'll take a look at what our results say. Okay, let's take a look at what we have here. So yeah, a number of you, and this shows the other side of the coin that I probably should have talked about, is that yes, while there are a number of legislative efforts going through to try and pass these transgender bathroom bans, there are a number of states that are pushing back. There's governors vetoing these bills. There are individual houses of the state legislatures that say, no, this is not going to go on our books. And so it's something that we see both sides. And it seems to be every day that this trend of, oh, more are passing. And then it switches back. Oh, they're failing now for a variety of reasons. Last, I thought this was an interesting one, that sometimes it's not even the legislation enacted that will force a school district to move. In Tennessee, there was a singular state legislator who threatened to appoint 6 new members to the largest school district in his district because he thought they were mismanaging it. He didn't agree with how they were conducting the superintendent search, which I understand, very contentious. But he's not a local official. He's a state representative, and he alone was threatening to pass this legislation. And the school district, they knew that he likely had the power to do this. So they said, okay, we'll work with you. And the legislature took back his threat and said, okay, I'll pause, but you have to give me this improvement plan for how, even with this new superintendent you picked that I disagree with, you're going to solve all these issues that I placed upon you, which, again, it not only shows this threat of legislation, state legislation affecting school districts, but how this kind of oversight that we've not really seen in the past. Now, enough about the legislation that I'm sure you guys have a Google alert set up every time that some new state statute gets passed. We also have the attorney generals threatening legal action against these various school districts. For one, the California Attorney General has been very active. This was one where he actually ended up initiating a lawsuit. So this Southern California school required parents this kind of parental transgender notification. Anytime a student asked to use a different name or pronoun, use facilities that didn't align with the sex assigned at birth, or asked to participate in programs that didn't align with their sex assigned at birth, they were required to notify the parent. California Attorney General came in and said, that is illegal under California's Constitution and California's Education Code, which prohibits discrimination based on transgender status. And the court agreed with the California Attorney General, said, school district, you cannot do that. That is in violation, at least at the initial stage. And so they got a preliminary injunction preventing that policy from going into place. Then, following this win, the California Attorney General issued a legal alert to all California schools that their forced disclosure policies are illegal and unconstitutional, and says that you should change it. And the school district in question after that, in March 2024, they updated it to only tell parents that the student has requested a change to their records. So these parents would get this email, this weird email that was like, your student has requested a change to their student records. And these parents were like, what does this mean? And the school's intent, it is believed, is to try and skirt around. They're saying they're not discriminating against transgender students. They're actually, it applies to everyone equally. That has not made it through the courts yet. As you can see, it's relatively recent, as soon as March. On the other side of the coin, want to be very clear that this is not just a red state or blue state thing. This is every state. We have California's Attorney General, Democrat, and now we have Missouri's Attorney General, a red state, and issued cease and desist claims to various school districts who he alleged were applying different standards to different races for admissions to their local school districts, for their magnet schools. And the district's response was simply that he doesn't understand the program. And those were relatively recent claims that, again, have not made their way through any legal action. But we've seen before, for example, with the California Attorney General, even the threat is enough to move, or the Tennessee school boards, just the threat of it is enough to move them. And then last for the Missouri Attorney General is, this was a really interesting one that kind of shows you how much states may be willing to work to infringe on this kind of idea of local control, which is, in March, there was a off-campus, it was a few blocks away from the campus, was my understanding from the reporting, after school assault of a white student by a black student. The Missouri Attorney General said that this was the result of the school's, you can see it right there, radical DEI programs. And the school, he alleged, was mismanaging funds. And because they were putting so much into this DEI programs, they were letting the community policing and the safety issues go by the wayside. And the district's response was kind of exactly what you'd expect. This is racial bias against majority minority schools. And they questioned why he was not having these same thoughts towards the majority white schools. And now I'm going to turn it over to Mary, who's going to walk us through kind of these other two ways that states exert control over the local school districts through the state departments of education and through governors.
Thank you, Eric. Thanks everyone for attending today. That was really interesting, Eric. Some nice tidbits that I hadn't even read about or heard about in a variety of states and contexts. So thank you for that. So let's talk a little bit about the political pressures that can come from state departments of education, which I know you all are familiar with. Let's start with this idea of charter school authorizers. So we know that charter schools have just continued to proliferate since the early 90s. The charter school idea, actually, let's not forget that it was really championed. It was a progressive movement, not necessarily a red or blue movement, but a progressive movement. Actually, around the late 80s, the president of the American Federation of Teachers endorsed the idea. And so you saw over the course of several presidential administrations, bipartisan support for the proliferation of charter schools. And so it continues. And in the past 15 to 20 years, it's I think the charter school population has increased at least sixfold. So as of late, there are a handful of states that have only state charter school authorizers. So it varies in the 50 states, but that is one mechanism that a state can exert influence by having a statute that says that only the state agency can authorize charter schools, even if it's objected, if there's an objection by the local school board. Sometimes you'll see the state body having authority only if the local school board has chosen not to register as an authorizer. That's a pretty common format that the states use. But at least within about 5 to 10 years ago, there were only about 10 states that had full state authorizers. And sometimes that can be good and sometimes that can be bad, depending on your perspective and depending on who sits in the state board for the authorizing of the charter schools. There's an example that we're kind of anxiously awaiting to hear about in Oklahoma right now, wherein Oklahoma has a state authorizer for virtual charter schools. And that state authorizer for virtual charter schools recently, I think it was in October of last year, authorized a religious charter school, the first one that we know about in the nation. And it's currently being taken up by the Oklahoma Supreme Court. They heard oral arguments back in April. But interestingly enough, the state attorney general is actually brought the lawsuit to, quote, undo what he says was the unlawful sponsorship of the charter school. It's a Catholic charter school, interestingly enough. And it takes me back to the case that John talked about earlier in the presentation, way back in the early 1920s, in the Pierce versus Society of Sisters, which in that case, there was an unlikely alliance between actually the Ku Klux Klan and some Protestant groups in opposition to the case that was brought by, again, a religious, Catholic religious school. So it's very interesting when you break it down. You can even have different religious groups pitted against each other, such as in this case. So right now we're waiting for that case to be decided. The school is saying that this is an issue of free exercise. Of course, the Attorney General is saying this is an issue of establishment, and that the charter school authorizer, the state charter school authorizer, basically they broke the law and they overstepped their authority. They claim that they did not. By the way, it was a 3-2 vote by that board, and they claim that it was a discrimination issue and a free exercise issue, and if they hadn't authorized it, then it would have been violating the Constitution of Oklahoma. So we'll await that case. Switching gears a little bit, let's talk about the disregard for the recent Title IX regulations that were issued by the current presidential administration. It came out in 2024, we all know about. We know that when Joe Biden first took office in January of 2021, he issued an executive order basically taking the position that sex discrimination extends to sexual orientation and gender identity. And his position was that this was in line with the Supreme Court's Bostock versus Clayton County decision. So he issued that executive order, and then we started to see a lot of backlash from there. And at the same time, also the United States Department of Agriculture issued guidance saying that it was interpreting the president's memo and the Bostock case to apply to sexual orientation and gender identity. And so any districts that had policies that enable discrimination on the basis of sexual orientation and gender identity could risk losing their federal funds for school lunches and so on. And then you started to get a lot of pushback. Just recently in Florida, the Department of Education, led by Commissioner Manny Diaz Jr., issued a memorandum to all Florida districts saying, don't comply with Title IX regulations, and that those regulations should not be treated as governing law. They are not binding on Florida. In his memo, he used words such as maim, gaslight, and commandeer to refer to President Biden and the issuance of the regulations. So he also said that the regulations will cause districts to violate Florida's Fairness in Women's Sports Act, which was signed into law in Florida in 2021, basically banning those with biological sex as male on their birth certificate in participating in any female sports. So the saga continues. We also have Governor Abbott in Texas, who penned a letter to President Biden saying basically that his regulations were illegal and that he exceeded his authority, trying to institute his leftist beliefs and so on. So for those of you who are in districts that are challenging these regulations, which I think now is up to 22 states that are actually challenging the regulations through various lawsuits. If you're in any one of these states, we understand the predicament that you are in and having a direct conflict between what is possibly your state law or guidance and your federal regulations. I wish that we had an answer for you now on how to proceed, but you know that we don't. So we'll keep our eyes on those lawsuits that were brought by the different states and their attorneys general. It's several different lawsuits. It's not 22 different lawsuits, but it's 22 states. Some of them have joined together. And I think it's probably about 6 or 7 lawsuits, maybe 4 or 5, somewhere between 5 and 7 probably. And I could name the states for you, but there are way too many. So you probably know if you were in one of those states. Has your district heard anything about whether you should be following the new Title IX regulations? We'd like to know. Hopefully you know the answer to this question. Maybe you don't. I think, yeah. So A is yes, the state said that you should follow them or shouldn't follow them, or yes, the board said you should or shouldn't follow them, or no, you haven't heard anything. Curious to know if you've heard anything on what to do with the Title IX regs, which go into effect August 1st of this year, by the way. Let's see. So, even split between yes, the board told you, or yes, the state told you, or and then no. So most of you actually haven't heard anything. That's interesting. Most of you haven't heard anything. I guess no news is good news. So I guess you proceed to start to revise your policies based on the new regulations, and then I don't think, though, that we'll have a resolution to these lawsuits before the effective date of August 1st. So that leaves people in a difficult position, understandably so. Okay, another way that departments of education have been heavy-handed is to basically threaten individuals with various things. Florida, again, we talk about Florida a lot, and I know that everyone knows that the governor of Florida had previously made a presidential, tried his hand at running for president, and was probably using a lot of these culture, as they're called, culture wars, cultural issues to try to test the waters, and unfortunately using school districts as sort of guinea pigs in this endeavor, which is all for naught because he withdrew from the race. In any event, there was a lot of fallout from these cultural issues, and we see Florida a lot as the leader in this, Florida and Texas. But in Florida in particular, because of the presidential aspirations, it seems like it was even more than one might think. So one of the things that the Florida Department of Education did along the way was threaten to revoke the license, the teaching license, the educator certificate of a superintendent. So this was the superintendent of Leon County Public Schools, which is the Tallahassee area. I'm not a member of the council, but still a pretty important county in Florida because that's the seat of the state government. So Rocky Hanna, the superintendent, had openly opposed Governor DeSantis first with the mask ban that DeSantis issued, basically defying it. They actually had a 3rd grade student who died from COVID during that time, and the numbers of COVID cases in that county had spiked, and the superintendent basically defied the ban on masks. And then he subsequently also, he basically outwardly opposed what he called the Don't Say Gay bill, or what they call the Don't Say Gay bill, also known as the Parental Rights in Education Act. And so despite the fact that in 2020 he was elected to a second term with 60% of the vote in his county, he was threatened with investigation based on, if you believe the sources that you read, based on one complaint by a member, a leader of a local chapter of the Moms for Liberty, which you've all heard of, which is a conservative education advocacy group. The complaint requested his removal. And from one source that I read, her letter of her complaint was actually stamped with the phrase, "Let's go, Brandon." I just thought that was an interesting little anecdote there, which is a code name that conservatives use to replace a vulgarity that's been used against President Biden. In any event, even though Superintendent Hanna wasn't required to have a teaching certificate in order to be superintendent in his district, he was, again, an elected superintendent, which in Florida, at least in probably other states, you'll have a mixture of elected and appointed superintendents. He was in fact elected. And even though he didn't require a teaching certificate, he did agree to settle the case with the Department of Education. I'm sure he didn't want to lose his certificate also, and he also just didn't want to drag out the drama. He wanted to focus on the business at hand, which was running the school district. So he agreed to, I think it was 2 years probation on his certificate and a $1,000 fine. And also, if he ever is to be employed in a position where he needs to have a teaching certificate, then he's required to take courses, college level courses in leadership and ethics. He was quoted in one source to say that he does know that Ron DeSantis actually has removed other elected officials. Probably the most notorious was the incident where DeSantis removed the prosecutor in the Tampa Bay area, who subsequently won his 11th Circuit case. However, the 11th Circuit couldn't reinstate him under state law, but they did say that DeSantis violated his free speech rights. So nevertheless, Rocky Hanna saw the writing on the wall and figured, for him, it wasn't worth letting them go forward with the quote-unquote investigation against him for failure to follow state law, basically, the long and short of it. All right, what's another thing that we've seen happen to local control is when you have basically just state takeovers of the school district, which is pretty extreme, but we do have the majority of states that do allow for state takeovers, ever since the onset of No Child Left Behind and then school accountability and improvement. This has been one mechanism built into the law that if you don't show improvement of your students, eventually you can actually lose your school or schools. So there have been examples of this across the country. Not really sure how effective this is. I mean, there's been at least one book written by a political scientist who finds that there's really no improvement in academic or financial accountability when there's a state takeover. But this does happen. In the case of Houston, which is one of the largest known and the most recent, it started because there were a lot of dysfunctional issues happening on the board under the district's leadership at that time. There was one high school that had a failing grade for like several years in a row. And the Texas Education Agency first threatened to take over Houston schools in 2019. That went to court and it was sort of held up with injunction and so on. In the meantime, the Texas Education Code was revised, and because one of the arguments made was that the state didn't give the district due process. So they went and revised the Texas Education Code and built in a whole set of due process requirements. Anytime that a local school district is being subjected to a special investigation, and a special investigation can come for several reasons, one of them being a significant pattern of decreased academic performance. Now, opponents of the takeover argued that in the in the course of all of this happening, the district has improved. They have a B rating by the state, Texas Education Agency. Most of the board members who had been accused of dysfunctional leadership were gone. There were new board members, but nevertheless, in January of last year, the Texas Supreme Court basically ruled in favor of the TEA and allowed the case to continue in court, vacated the injunction, and the state went ahead and replaced the local school board members with a board of managers. And then they installed also a new superintendent who happened to be the CEO of a charter school company. But he had previously also been a school superintendent, a public school superintendent. But under his leadership, there's been recent protests and walkouts by teachers because under this new superintendent's leadership, he's implementing this new reform program, as he calls it. And from what I've read, the teachers are basically given scripted lessons to teach with their students. And also their pay is tied to standardized test scores and proficiency screening. So this is very controversial. This is even as of March, there were a lot of teacher walkouts, teachers quitting. It's a bad situation. Again, the effect, teachers have had to reapply for their jobs, principals have been threatened with their jobs, and the ACLU, though, picked up the torch, and even though the Houston School Board, which is really no longer in their seats, they voted before the installment of the board of managers, they voted to drop the lawsuit because they just felt like so much money had been spent on the lawsuit, and obviously none of our districts can afford a long, protracted litigation. So the ACLU has also sued on behalf of parents and students, claiming basically that this takeover is disproportionately affects the voting rights of Black Americans. Interestingly, the Houston Independent School District is majority Black and Hispanic, and sources talk about some of the difficulty with the board that had been happening prior to the new board. There was a lot of this dissension between board members of different races on the board. Okay, back to Florida. Another method of political pressure has been Governor DeSantis endorsing in the last couple of elections various school board members, and this was kind of disconcerting because for decades and decades, school board races are not nonpartisan. They're officially nonpartisan, and really the governor just didn't get involved in local school board races. So he endorsed 30 candidates, and the majority, 24, I think it was actually 25, because one may have run in a runoff, but this is another tactic of political pressure that the state has used in actually replacing local school board members through endorsements. And then we know about the parkland, the suspensions of Broward County school board members after the very unfortunate tragedy in the Parkland shooting, which the grand jury was impaneled to investigate the incident, the shooting incident, and ended up spinning off and coming up with a report about the bond project that related to school safety and construction. And as a result of that investigation, they ended up recommending the ouster of 5 board members. One had already left to the state Senate, and actually Ron DeSantis actually suspended 4 of them as a result of that investigation. So a suspension of board members is another tactic. And then he replaced, at that time, he replaced what had previously been an all-female board with all-male replacements. There were some females that remained on the board who were not suspended, and made basically Republican appointees. They've since had an election, and the board has leveled out a little bit more with regard to, the right-leaning, left-leaning members. But still some of the governor's candidates remain. Let's see. Then we switched to California, which is similar but different. Governor Newsom using his sort of strong arm to convince a local school district to refuse to adopt a social studies curriculum, basically threatening them with over like $1.5 million in fines if they didn't adopt it. This district had been opposed to the curriculum because the curriculum requires that students be taught about the contributions of gay, bisexual, and transgender Americans. And the Temecula district refused to adopt this curriculum. So the governor stepped in, and by the way, the curriculum was actually recommended by the district to the board. So the governor and the attorney general of California stepped in and basically required the board to explain their reasoning of why they wouldn't adopt and follow the CETA process through the board president basically said that Governor Newsom was attempting to usurp local control, which is what we've been discussing here. And like Eric pointed out earlier, you know, it's red states, blue states. You can see a little bit of these tactics being used by both political parties. Ultimately, the Temecula board gave in, begrudgingly, you know, making statements that they really don't, you know, they didn't appreciate it, but nevertheless, they gave in. Finally, we have the example of districts that just decide to spin off if they're not happy with what's happening in their district. There's a couple of examples of this. In Louisiana, there's a state statute that allows a new school district to be created if there's a new municipality created. So originally, part of the Baton Rouge school district tried to break off directly through a state statute, and didn't prevail. And so they actually had to go the route of having a new municipality formed so that they could spin off and have a new district created that way. So they actually did successfully break away. Baton Rouge is going to lose a significant amount of funding. And obviously, as you can imagine, going to leave more poor and minority students in the district. Of course, the part of the district that broke away is St. George's residents who have more means, as you can imagine. And then we had a similar example of this happening in South Bend, Indiana, where a wealthy suburb of South Bend wanted to separate and was permitted to do so under state law. So I guess when all else fails, locally, then people just decide to create their own city, their own districts. And that brings us to how do we push back, if at all?
Yeah, so thank you, Mary, for walking us through that. You know, we went through all the ways that the state tries to combat local control and dismantle it. And so it was a bit, you know, glum for our number of council members and school districts that are here, but it's not all bad. And so there's ways that we can push back upon, you know, these attempted state interference with local control. First of all, it's that a lot of these state laws, not a lot of the ones that we presented here, but a number of them are optional. The states can elect to, or the school districts can elect to have those options for them. We see this frequently when we hear discussions of arming teachers, which has also become a hot topic. You have a choice in that. You can think, what is best for your district? There's one story out of Tennessee when Tennessee allowed school districts to arm their teachers. One county school said, we're not going to do that. We have our school resource officers, and we have safety drills, and we have policies in place to keep our students safe without empowering, without requiring our teachers or allowing them to carry guns. We simply don't need them. So it's always important that, you know, you see these headlines that might not tell the whole story. Take a look at the statute. Do you actually have to do something your district doesn't want?
Another option we talked a little bit about is obviously you can bring forth civil litigation and ask for judicial intervention. We know that this is difficult because you typically have to get your boards to agree to this, but this can be a very effective option, especially if you're trying to get temporary preliminary injunctive relief. This happened in New Mexico just last month when the state was trying to add more school days, and a judge has stepped in and stopped that. So, you know, that's there at your disposal.
So we talked earlier about how in many of these situations there's a conflict between state and federal law, and in those situations, sometimes the issue gets resolved through litigation, but you also have the option of trying to use a federal administrative agency to support a position. And so here's an example where the Department of Education's Office for Civil Rights is investigating a Texas school district because it's implementing a policy mandated by the state. And so the federal government may force the district in that way back to its prior policy. The same thing sometimes happens on funding issues. I remember a case where a particular state was not providing Title I funding appropriately, and the district was able to go to the Department of Education and get the Department of Education to intervene and explain to the state that the district's point of view on this was actually correct. And so that's definitely an option. We also talked earlier about the Houston situation where the ACLU has stepped in carrying on voting rights litigation. You can definitely work with allies, but you can also do grassroots lobbying. You can work in the legislature. You know, in a number of states, the recent trend of expanding voucher programs has been countered by political movements that have pushed back against that in several states, and that's a real shift from what we saw several years ago. I apologize we went a little bit over today, but if you're interested in these topics, please consider subscribing to our blog. We also normally do these webinars every 2 months during the school year, but we're going to give you a bonus webinar this year because the Title IX regulations came out and the effective date is August 1st. So we're going to do a webinar on the new Title IX regulations on June 13th, again at 2 o'clock Eastern time. If you're interested in that particular program, the invitation is already out. It went out by email today, and it can also be found in the program materials folder at the bottom of your screen.
It has not gone out by me yet, John, but thank you. It will go out today.
Okay, it went out to our mailing list, which has some overlap with yours, but is not coextensive. So you'll get it one way or another. If you're in this webinar, you'll get it today or tomorrow. With that, thank you very much for joining our program today. We hope the information provided was helpful for you and your organization. As a reminder, the program has been approved for continuing legal education credit. To report your hours, click on the CEU button at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing within your organization. Please be sure to complete our short survey. We'll use your feedback to plan programs for next school year, and we want those programs to be as useful for you and your districts as possible. Thanks again for joining us today. We hope you finish out the semester on a high note, and this concludes our webinar.
Thank you, everyone.